Judges come to the oral argument having read the brief, so they have some predisposition as to how they're going to vote in the case. Oral argument really is an opportunity for the lawyers and the judges to have a discussion about the case.
It's not a comparative analysis where you say, well, the worst form of a burglary occurs when the defendant does this precise act.
What evidence would be admitted for a prosecutor to show it's the worst and for a defense lawyer to show it's not the worst?
For the justices to be sure we understand the strongest arguments of the lawyers, for the lawyers to, when they leave the courtroom, to hopefully leave with a feeling that, well, if I win or lose, at least the court, the justices understand my arguments.
This was either a benign crime or this was a heinous crime or somewhere in between, correct?
Correct.
That's the reason that when someone visits here, they see a fairly lively discussion among the justices and the lawyers.
In the oral argument, you want dialogue with the court. You want give and take, because you want to know what's troubling the justices or what questions they have on their minds.
Most defendants, we can presume, will plead guilty or some sort of bargain will be struck as to any aggravating factor.
We can't fashion law based on the gamble that somebody's going to plead guilty.
The argument before the Ohio Supreme Court is your last chance for justice, your last chance for advocacy for the client.
Thank you.
Thank you.
The case is submitted. You'll be advised of our opinion. We'll take a brief recess.